Hello everyone, welcome back to the Let's Dream Civils YouTube channel. Today's topic of discussion is expanding the judicial capacity and analysis of the Supreme Court Number of Judges Amendment Ordinance 2026. In this video, we will discuss about this ordinance, its institutional impact, and the constitutional provisions which support this ordinance. The structural change. On May 16, 2026, President Draupadi Murmu promulgated the Supreme Court Number of Judges Amendment Ordinance 2026 based on the recommendation by the Chief Justice of India, Surya Kant. So this ordinance amends the Section 2 of the Supreme Court Act 1956 and it increases the sanctioned strength of the judges of the Supreme Court from 33 to 37 excluding the Chief Justice of India. So if we add the Chief Justice also, then the total strength is now 38. The pendency crisis. What is the primary reason behind this 2026 ordinance? The primary driver behind the 2026 ordinance is an unprecedented backlog, which means that the Supreme Court is handling too many pending cases. The Supreme Court reportedly has around 93,000 pending cases before them. So because of this huge backlog, courts are taking a long time to give judgments, which delays the justice for the common citizens. Post-COVID, the number of cases increased rapidly for several reasons. First reason is e-filing of the case. People can now file cases online more easily. So more cases are reaching the court's doorstep because they have become more accessible in the recent days. The citizens and groups are approaching the courts on issues related to public welfare and governance, so more public interest litigations are getting filed. The commercial related conflicts and disputes involving the government policies have also grown at a higher rate. As a result, more cases are coming to the Supreme Court than the court can dispose them. So the intake rate outpaces the disposal rate. This is one of the main administrative reasons behind this ordinance. Now let's look into the constitutional framework behind this ordinance. Article 124. Article 124 of the Constitution establishes the Supreme Court of India. The clause 1 of Article 124 says that the Supreme Court will have one Chief Justice and such other judges will be decided by the Parliament through law. So this means that the Constitution itself has given the power to increase or decrease the number of Supreme Court judges whenever needed by the Parliament. Using the power under this article, Parliament passed the Supreme Court Number of Judges Act in the year 1956. By amending this law from time to time, the Parliament can expand the Supreme Court's judicial capacity to meet the expanding litigation and the pending cases. Now let's move on to Article 123. This article grants the power to the President of India to issue an ordinance when either one or both the houses of the Parliament is not in the session, when the government feels there is an urgent need to make a law immediately, or when an unforeseen situation which needs an immediate executive action. In this case, the budget session of the Parliament ended on April 2 and the monsoon session is yet to happen. So the President used Article 123 to quickly bring the ordinance without waiting for the next session. However, an ordinance is a temporary law, even though it is immediately functional. Which means, when the Parliament meets again, it must approve this ordinance within 6 weeks. Which means when the Parliament meets for the monsoon session now, right? Because the budget session is over, then they will meet again for the monsoon session. When they reassemble, the Parliament has to accept this ordinance within 6 weeks. If they accept it, the ordinance will become a permanent statutory law. Otherwise, the ordinance will lapse. The growth of the judicial strength. This table shows how the strength of the judges in the Supreme Court of India has gradually increased from time to time to match the expanding responsibilities of the judiciary. In the year 1950, by original Constitution of India, the total strength of the Supreme Court was 8, including the Chief Justice of India. And then in the year 1956, the Parliament passed the Supreme Court Number of Judges Act, which changed the strength to 11 judges. Then the first amendment of the Supreme Court Number of Judges Act happened in the year 1977, which increased the strength to 80. And then in the year 1986, second amendment happened and the strength is increased to 26. In the year 2019, the strength was increased to 34 judges by the third amendment of this act. So now in the year 2026, we have the ordinance, not the act yet. It has to be approved by the Parliament in the monsoon session. So according to this ordinance, we now have 38 judges in the Supreme Court. The Constitutional Bench shortfalls. Under Article 145(3). Before moving to that, let's see this line. The expansion directly unlocks specialized and constitutional adjudication, which means increasing the number of judges is not only about reducing the pending cases, it will also help in handling the important constitutional matters more efficiently. How? Let's look into that. The constitutional demand. Under Article 145, Clause 3, any case involving a substantial question of constitutional interpretation must be heard by a constitutional bench of at least 5 judges. When the judges are assigned to constitutional benches, only fewer judges remain for the hearing of regular appeals and routine matters. So staging these blocks the routine appellate courts. And then we have specialized benches. So these benches will take care of the complex issues such as governance related disputes, interstate tax issues, and interstate water issues, and regulatory challenges. So these type of issues require judges with specialized focus. So we need permanent dedicated benches to improve efficiency and expertise in such cases, relieving the judicial question. By increasing the number of Supreme Court judges to 38, the Supreme Court can handle both constitutional cases and routine cases simultaneously without creating judicial gridlocks. The beyond judge numbers. Simply increasing the number of judges alone will not fully solve the India's judicial backlog. Broader judicial reforms are also necessary. Faster appointments in the High Courts. The Supreme Court expansion must align with the fast-tracking appointment in the High Courts. Many High Courts in India are already facing a serious shortage of judges with vacancy levels around 29%. So delays in the judgment of High Courts will eventually increase the judicial burden of the Supreme Court. The next step to be taken is strengthening our alternative dispute resolutions like mediation, arbitration, and Lok Adalat, so that we can stop the disputes reaching the courtrooms by providing faster judgments here, so that it can save both time and the judicial resources. Then we have technology-driven judicial reforms such as e-courts, AI-based case management systems like digital case filing, digital file tracking, and then smart scheduling of hearings can also speed up the case. Then the pathways to systemic efficiency. We have to promote the lower judiciary excellence. Because to truly improve India's justice delivery system, reforms must strengthen the judiciary at every level, not just the Supreme Court. Implementing an All India Judicial Service under Article 312 of Constitution to recruit top-tier uniform legal talents for lower courts as well, because most citizens approach the district and subordinate courts. Therefore, improving the quality of lower judiciary is essential. And then modernizing the judicial infrastructure. Reforms include expanding the physical space, that is, court building and hearing spaces, appointing more specialized law clerks, improving digital systems, and using intelligent case tracking and scheduling software. Thank you everyone for watching. If you find this video helpful, kindly subscribe to the channel for more such informative videos. Thank you. Stay tuned.